All right. Good evening, everyone, and welcome to the Daniel Webster Debate Series. This series was named in honor of Daniel Webster, one of our nation's greatest orators, public servants, and advocates. Founded just last year, the series has already become the heartbeat of our chapter and a cornerstone of the intellectual conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage the most pressing legal and constitutional issues of our time. Tonight's resolution, does the President have the authority to implement massive tariffs, could not be more timely. Questions of executive power, particularly in relation to President Trump's actions, have dominated national debate this year and will set the tone for the upcoming Supreme Court term, with the court hearing oral arguments on this very resolution on November 5th. Therefore, it is my honor to host tonight's program with a practitioner and scholar who have been leading forces on this issue, and I'm equally honored to have our Interim Dean join us in moderating this important exchange. So without further ado, please join me in welcoming our Director of Debates, Louis Pham, who will formally introduce these three distinguished panelists. Thank you so much.
Good evening, everyone, and thank you for coming. Our moderator tonight is Dean Joshua Teitelbaum. He is the Interim Dean of Georgetown University Law Center and Executive Vice President of Georgetown University. He's also the David Belding Professor of Law and a Professor of Economics. His research interests lie primarily in decision theory and related fields in microeconomics and their intersection with law and regulation. His work has appeared in American Economic Review, Econometrica, the Journal of Legal Studies, and the Journal of Empirical Legal Studies, among others. He previously served as the Associate Dean for Research and Academic Programs for the Law Center, as an editor of the International Review of Law and Economics, and as Associate Editor of the Supreme Court Economic Review. Before coming to Georgetown in 2009, Dean Teitelbaum clerked for Judge Richard M. Berman of the U.S. District Court for the Southern District of New York, practiced corporate and securities law at Cahill Gordon in Rhinedale in New York, and was a visiting assistant professor at Cornell Law School. He holds a PhD in economics from Cornell and a JD from Harvard Law School. On the affirmative is Professor Chad Squitieri. Chad Squitieri joined the Catholic Law faculty in 2022 after having practiced law at Gibson, Dunn & Crutcher as a member of the Appellate and Constitutional Law and Administrative Law and Regulatory Practice Groups. He previously served as a special assistant to former United States Secretary of Labor Eugene Scalia and as a law clerk to then Chief Judge D. Brooks Smith of the United States Court of Appeals for the Third Circuit. Professor Squitieri's scholarship addresses administrative law and constitutional law topics. He served as a faculty advisor to the Catholic University Law Review, a managing director of the Center for the Constitution and the Catholic Intellectual Tradition, and director of the Separation of Powers Institute. In 2024, he was honored with the Teaching Award of Outstanding Professor for Evening Classes. In 2025, he was appointed to serve on the Administrative Conference of the United States. On the negative is Mr. John Vecchione. He is a senior litigation counsel for the nonprofit New Civil Liberties Alliance, representing clients against the administrative state. He was previously president and CEO of the nonprofit Cause of Action Institute, also advocating the constitutional order. He has practiced at a number of DC area law firms and focuses on strategic litigation in federal district and appellate courts, including the Supreme Court of the United States. He was counsel of record for Relentless petitioners in the landmark case Loper Bright Enterprises versus Raimundo and Relentless versus Department of Commerce, and for 4 individual respondents in Murphy versus Missouri. He is an experienced trial and appellate advocate, having tried cases and argued appeals across the country. He is a member of the bars of the state of New York and the District of Columbia and the Commonwealth of Virginia, as well as the Supreme Court of the United States. His cases are reported in scores of published opinions, and he has also published pieces advancing the freedom agenda and constitutional order in the Wall Street Journal, the Washington Times, and other forums. He graduated from the University of Virginia Law School and Florida State University.
No, he didn't.
Nope.
Georgetown University Law School.
Oh yes, my bad. We have an error on our sheet. He is a Georgetown alumnus. We have the Squitieri bio.
UVA and FSU was me, but otherwise, excellent job.
My apologies. Yeah. And with that, I welcome tonight's debate.
Okay, good evening and welcome everyone. I'm Josh Teitelbaum, the Interim Dean here at Georgetown Law, and I'm really delighted to join all of you for tonight's debate. As an institution of higher education, one specifically committed to the Catholic and Jesuit tradition, Georgetown is committed to free and open inquiry, deliberation, and debate in all matters, and the untrammeled verbal and nonverbal expression of ideas. These are cherished values within our university community and essential components of academic life. I'm a great admirer and supporter of the Daniel Webster debate series, now in its second year at the Law Center, because it models and upholds these important values. Civil discourse is especially important in a law school. Learning to channel the passion of one's principles and ideas into reasoned, persuasive arguments is an essential part of learning to be an effective advocate. This evening's debate will address the question of whether the president has the authority to implement major tariffs. Unlike tonight's distinguished debaters, I am not an expert on this subject or the underlying constitutional and statutory authorities and legal doctrines. Having read some of the debaters' writings on the subject, I expect that we will hear opposing views about whether the International Emergency Economic Powers Act, or IEPA, by empowering the president to regulate importation, empowers the president to impose tariffs, and about the related questions of whether the imposition of tariffs are an exercise of the taxation power or the commerce regulation power under the Constitution, and whether interpreting IEPA as a delegation of tariff authority runs afoul of either or both of the non-delegation and major questions doctrines. I will be very interested to hear the debaters' views on these legal questions. But I'm an economist as well as a lawyer, and so after we hear the debaters' opening statements and rebuttals, I plan to ask them at least one question from the economist perspective before opening the discussion to questions from the audience. Before we begin, I would like to thank Dennis Asvalinsky and the Georgetown Law Federalist Society for organizing tonight's program and for this year's entire lineup of debates. And of course, I'd also like to thank our debaters, John Vecchione and Professor Chad Squitieri, for joining us. And now I invite our debaters to make their opening statements. I think we will begin with you, Professor.
Great. Well, thank you very much to the Federal Society in Georgetown for having me. My talk today builds off an amicus brief filed on my behalf in this case, and that amicus brief built off some of my academic publications. So if you want more detail on my talk today, or the director's cut, so to speak, please check out those publications. And I also want to start off by saying I have a tremendous amount of respect for John and his organization, NCLA. Normally we're on the same sides of these issues, and I look forward to hopefully being on the same side again in the future. But tonight we have our disagreement on this topic, and so my role is to explain why I think my position is the correct one. And my position is that a statute, as Adine mentioned, called IEPA, empowers the president to impose the tariffs that are being challenged in the consolidated cases at the Supreme Court this term. So let me break that down. IEPA empowers the president to, quote, deal with, quote, unusual and extraordinary threats by taking a few different actions in regards to imports. At one end of the spectrum, the statute empowers the president to investigate importation. At the other end of the spectrum, the statute empowers the president to prohibit importation. Here, the president has used the power in the middle of investigate and prohibit, and that's the power to, quote, regulate importation. And the government takes a position that the phrase, regulate importation, includes the power to impose tariffs, and the government is correct. Since the founding, tariffs have been a traditional and well-known means of regulating foreign commerce. So the ordinary reading of regulate importation encompasses the traditional power to regulate importation via tariffs. Nonetheless, two lower courts ruled that IEPA did not empower the president to impose the challenge tariffs. So how could this be? Well, the analyses of both of the lower courts run through a shared choke point. And that shared choke point was that tariffs have to be an exercise of taxation power. And so the court said something along the lines of, look, IEPA does not use the word tax, and instead uses the word regulate, and tax and regulate are different, so IEPA does not include the power to tax via tariffs. The problem with that logic is that not all tariffs are exercises of the taxation power. For over 200 years, tariffs have, 250 years, tariffs have been understood as exercises of the power to regulate commerce. And so the originalist evidence on this is really overwhelming. It finds support in the writings of James Madison, Chief Justice Marshall, Joseph Story, and the revolutionary pamphleteers. The pamphleteers conceded that although Parliament could not tax them without representation, Parliament could regulate commerce via tariffs. So from the nation's start, it's been understood that there's a distinction between tariffs and taxes. The view that tariffs can be an exercise of commerce regulation power also finds support in the Tariff Act of 1789, which was signed into law by George Washington on the 4th of July. It doesn't get much more American than that. It also finds support in various Supreme Court precedent. So in sum, the originalist evidence is overwhelming. Tariffs need not be an exercise of taxation power. They can instead be an exercise of commerce regulation power, and that is relevant because, recall, IEPA empowers the president to, quote, regulate importation. So viewing that statutory power in the context of 250 years of history, it becomes clear that the ordinary meaning of the phrase regulate importation includes the power to regulate importation through our traditional and familiar means, tariffs. So I'd therefore ask you to listen carefully, both to John and other challengers over the next few weeks, and see how much of the opposing argument turns on the mistaken idea that tariffs must be a tax. You might hear folks say, well, the founders didn't want the president to have a power to tax, or the non-delegation and the major questions doctrine apply differently to taxes, or IEPA doesn't use the word tax. The question that you should ask when you hear those types of arguments is, well, isn't it true that not all tariffs are taxes? Isn't it true that tariffs can be an exercise of commerce regulation power? And if tariffs can be a constitutional exercise of commerce regulation power, then why exactly does a statutory phrase empowering the president to regulate importation not include the authority to regulate importation through traditional means? Now, to be sure, the commerce regulation power is vested in Congress, not the president. So for IEPA to delegate commerce regulating authority, IEPA would have to survive scrutiny under the non-delegation and major question doctrines, but neither of those doctrines pose a problem. I'll start with non-delegation. Existing non-delegation precedent, which has not been challenged in this case, makes clear that the doctrine applies less stringently, if at all, in the foreign affairs context. This case is about foreign commerce, and so the lax to non-existent version of the non-delegation doctrine applies. But even if we were to apply the domestic version of the non-delegation doctrine, IEPA's delegation would still survive. That's because IEPA limits who can impose the tariffs, when the president can impose the tariffs, what the president can impose the tariffs on, when the president can impose the tariffs, the time length the tariffs can last without reauthorization, and the scope and magnitude of the tariffs, which is limited by a statutory requirement that IEPA tariff authority only, quote, may only be exercised to deal with an unusual and extraordinary threat, and may not be exercised for any other purpose. So just last term in Consumers Research, the court permitted a broad delegation of domestic taxation or commerce regulation authority. That domestic delegation did not impose any numerical limit on the executive branch. The amount of the tax or the fee was entirely up to the executive branch, so long as the amount was, quote, sufficient to, quote, support a government program. The court reasoned those terms were enough for non-delegation purposes. As the court reasoned, quote, if you told a friend to order a sufficient amount of food for 5 people and 500 boxes of pizza showed up at your house, you would not think the friend had followed the instructions. You can apply similar analysis here because IEPA limits the president to only imposing tariffs that, quote, deal with specific threats. So to paraphrase the court, if you told a friend to order food to deal with 5 people and 500 boxes of pizza showed up at your house, you would not think that he had followed the instruction. As a major questions doctrine, as Justice Kavanaugh recently explained, the court has never applied that doctrine in the foreign affairs and national security settings, nor should the court do so. For those justices who see that doctrine as a substantive canon promoting the constitutional value of non-delegation, well, those justices should allow the major questions doctrine to develop in a way that is just as sensitive to the foreign affairs setting as the underlying non-delegation doctrine is. And for those justices who see the major questions doctrine as a linguistic canon, those justices should account for the fact that Congress routinely delegates major authority to the president in those settings. Moreover, the major questions doctrine is not applicable in these cases for another reason, and that's because the president has not claimed, quote, unheralded authority as major questions doctrine cases have required. Nearly 50 years ago, the statutory phrase, regulate importation, the exact phrase at issue today, that phrase was judicially recognized as delegating tariff authority to the president. So this is not a new power pulled out of an old statute. This statutory power has been judicially recognized for nearly 50 years. 50 years this fall, actually. So in conclusion, my position is that IEPA grants the president the tariff authority he needs. So thank you.
Well, thank you very much. You know, it's funny, Chad's amicus brief has already been filed, so I got a little bit of preview in the case before the Supreme Court, and it's and it's filed by the lawyer Trent McCotter, who was the lawyer who lost Consumers Research. So perhaps he's trying another shot. And the Solicitor General was my co-counsel in Murphy v. Missouri, John Sauer. So I think this is a good example of my enemies I can deal with. God save me from my friends. But this is, I want to thank the Federalist Society. I want to thank Dean Teitelbaum for having us here and all of you for being here. It's my second Daniel Webster debate. And as I did last time, I checked on old Webster and what he said on various topics before I came in, but I really didn't have to. Probably the greatest oration in Senate history was Webster's second reply to Haynes. This is one of those speeches that every schoolboy used to know before cell phones were in the schoolroom. But it has become famous because its position on union and its famous ending, liberty and union now and forever, one and inseparable. But I feel very sorry for Professor Squitieri, because Webster had to do all that because he had a terrible position on tariffs. He had voted against tariffs when he was representing shipbuilders, and then he had voted for tariffs when he was representing domestic manufacturers. And the way he elided this was the same way Professor Squitieri has. He said, wait a minute, James Madison has come out with a whole thing, a whole letter in 1828 on the power in Congress to impose a tariff for the protection of manufacturers. And I'm just following him. I didn't have this before, but how could I not follow James Madison now? And I agree, we're at the Federalist Society. We should follow James Madison usually. But James Madison didn't say that this was a presidential power. What he talked about was the purpose of a tariff. And the argument was that you could not have a tariff to protect manufacturers the way Hamilton was. And it was kind of funny, Madison was following Hamilton for the reasons that Professor Squitieri said, because George Washington had signed that thing all those years ago. But he didn't say that the president has the power to impose this. He said Congress can impose a tariff for different reasons. They can do it for revenue raising, and they can do it to protect manufacturers and regulate commerce. So I don't think that the 1828 view of Madison is different from mine. Congress can do this, but Congress didn't do this. And I think it's very unlikely for textualist and originalist reasons that the Supreme Court's going to come out any differently. And by the way, you should all read, if you have never heard of it and you haven't done it, please read Webster's second response to Haynes, because it's very florid in our modern times, but it's just excellent. And there's lots more in there than just the ending. So one of the things that Webster said in that speech, however, and you can go read it, is that he also changed his mind, not just because Madison wrote his letter in 1828, but also because he'd lost the first vote in Congress on tariffs. It had become law of the land, and he wanted to protect like wool manufacturers. He said, Congress and the president sanctioned it, and it became the law of the land. That's Webster. Congress and the president had sanctioned these tariffs. Not the president, not some vague law that George Washington then said, you know what, I'm going to tariff everybody using this word regulate. That's not what happened. And so, that's Webster's view on it. He believes Congress has this power, as does Madison, as do I. But Professor Squitieri is stealing a base. And he's stealing a base because everyone thinks that Congress can regulate imports and tariff imports. But IEPA does not use the word regulate that way. And let me tell you why. The Constitution firmly places all revenue-raising powers, whatever they're being used for, in Article 1. And I'm just going to give you a brief synopsis of where it is. Article 1, Section 8, Congress shall have power to lay and collect taxes, duties, imposts, and excises. Those are tariffs. But all duties, imposts, and excises shall be uniform throughout the United States, Article 1, Section 8. It also says it has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes, and that's what Professor Squitieri is relying on for regulate. But then Section 9, also Article 1. This no longer applies for obvious reasons you'll all know, but it is important to what we're talking about. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 to each person. Again, import. It's in here, even in overruled parts of the Constitution, it belongs to Congress. Then this is the kicker, which is going to really, I think, end this argument about IEPA. No tax or duty shall be laid on articles exported from any state. And I'm going to read that again because it's important for IEPA. No tax or duty shall be laid on articles exported from any state. And then finally, Section 10. No state shall, without consent of Congress, once again, Congress has the power, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and it all goes to the Treasury, basically. So all this is where the power, whether you're doing it to protect manufacturers or you're doing it for some other reason, it's all in Congress. Now, what does IEPA do? IEPA doesn't use any of these words, not tax or duty or impost, not lay, not collect. Congress knew all those words in the 1970s. What it says is investigate, regulate, or prohibit certain foreign exchange transactions. Does that mean the president can tax those transfers? It's never been done. I don't think so. He can stop them. He can impound them, as he's done for the Iranian and other nations we've been having problems with. 1701, he has to declare an emergency. And as we've seen, here's the emergencies that have been declared. We have a balance of payments. We basically have a trade deficit, and there's fentanyl coming into the countries. Those are the two problems. And I guess because we have a trade deficit, we have our manufacturing, a manufacturing problem. It's killing our manufacturing. Now, none of that's true. I don't think any of these things are emergencies, but I don't think the court's going to look at that. But I do think it's in the background. I do think it's in the background, even though I don't think the court's going to say that whether there's an emergency or not is justiciable. But because these emergencies are kind of laughable, that is in the background. And so here's what IEPA says about regulation. 1702 says the president can regulate importation or exportation. Now, what do we know from what I just said is not allowed? You can't regulate exportation. It's unconstitutional. So regulate cannot mean tariff or impost or duty for any reason. Regulate is used in a different way because we know regulate in IEPA means regulate imports and exports. And we know from the Constitution that regulate cannot mean regulate exports because you're not allowed to tariff them. So this type of regulation of exports is not allowed. What you can do is embargo and do other things that presidents have done, but the very nature of what the Constitution says about this power to regulate exports and tariff exports prohibits the meaning in IEPA that Professor Squitieri wants us to adopt. So because that's unconstitutional and because there is not a symmetry between the constitutional use of the word regulate and IEPA's use of the word regulate, he's stolen a base a little bit. I don't think that there's any doubt that some of the founders said regulate, you can regulate for protecting manufacturers by tariffing. That's what Madison says, but that's not what the statute on IEPA said. And then let's look at IEPA. IEPA is not in the section of our laws that deals with tariffs. That's Title 19. And you go to Title 19 of the code, and it says Title 19, custom duties. And you look through it, IEPA's not there. You know why? It's not a tariff statute. They knew where to put them. They put them in Title 19. And Title 19 is replete. One of the questions about whether the president can impose massive tariffs, well, under Title 19 sections, like 232, yeah, he can, but he can't do it under IEPA. So that's the other thing that then we look. If this idea that IEPA allows these types of tariffs goes through, there are no other tariffs laws because no president will use anything else. So I then go to, I think that what's happened here is the Learning Resources case, which is Judge Contreras here in DC, and Voss Selections concurrence said that IEPA doesn't allow tariffs under any circumstances. They're just not tariff statutes. And I think that those textualist and original decisions are going to be followed by the court. But I'll just read you from Learning Resources what Judge Contreras says, and I think it's absolutely correct and it's hard to dispute. The court agrees with plaintiffs that the power to regulate is not the power to tax. The Constitution recognizes and perpetuates this distinction. And then he cites, as Chief Justice Marshall put it in an early leading case, the power to regulate commerce is, ... entirely distinct from the right to levy taxes and imposts. Gibbons v. Ogden, 22 U.S., and you can go cite it, and I'm sure you'll read about it in your constitutional classes if you haven't already. So I think the declaration of the two emergencies have already said the court isn't going to decide whether or not they're constitutional, or it's not going to say the president can't declare emergencies. But it is a little odd that he says that he's putting these tariffs in to protect domestic manufacturers, but he's also doing it for fentanyl. Is he protecting the domestic manufacturers of fentanyl? Is that the point? Because otherwise these things really don't match. So then the presidential power in foreign policy and national defense, they don't butter any parsnips in this case, because Harry Truman had an actual war against a communist invasion of an ally in North Korea, and he says, well, I got to make steel, so I'm seizing the steel plants. And the court, which was all appointed by either FDR or Harry Truman and believed in maximum presidential power in emergencies, said no. And I think we'll see that again. And then I do want to note, and I'm all done. And so the last part of this is, I do think that whatever the purpose, Americans are paying these tariffs and not foreign entities. So I don't think we can say that these have to do with foreign powers. And so, as for non-delegation major questions, I don't think the court has to reach it because it's a pure textualist. And so that's my rebuttal, and that's why I think the Supreme Court's going to come out on our side.
So I'm going to give each debater 2 minutes to briefly respond to the other's argument, and then I will start with the questioning.
Great. Well, John's remarks, I think, highlights a lot of things that we do agree on. So I'll kind of start with those. I agree that the power to regulate commerce is a congressional power. But as we know, Congress can delegate, despite work that John and I have been doing in other contexts. Congress can delegate authority over to the president. So the question comes down to does it satisfy the non-delegation of the major questions doctrine? So no dispute by me that it is a congressional power, but it can be delegated. And I think it's constitutionally delegated here. And when Congress delegates, importantly, Congress should not have to use magic words that a court happens to like, right? Yes, Congress could have delegated commerce regulating tariffs by using the word tariff or by using the word duty. Not tax, by the way. Tax is a distinct power. But tariffs or duty, sure. They could delegate taxation tariffs using the word tax, but not commerce regulation tariffs using the word tax. But just because Congress could use the word tariff or use the word duties doesn't mean they have to. Congress can instead say the ordinary meaning of the term regulate importation, right? Going back to the pamphleteers for 250 years, that means tariffs. So I think we can give words their ordinary meaning. I agree that tariffs can be taxation, but they can also be a form of commerce regulation. Two different reasons to impose tariffs, right? And the Constitution gives Congress flexibility in that regard. And I also agree that I don't think the court is really going to second guess much the emergency declaration by the president. I mean, the president talks about national security problems flowing from domestic manufacturing. You only need to think back to like COVID, where domestic manufacturers quickly transitioned to building things for the COVID-19 pandemic, or think back to World War II, when domestic manufacturers quickly pivoted from like making cars to making bombs and things like that for the war effort. Having a strong domestic base has real and significant national security purposes behind it. As to the export argument, I think that's probably one of the strongest arguments on the other side, but I don't think it resolves the issue because one, the IEPA gives a bunch of different verbs to the president. It can investigate, prohibit, regulate. All those same verbs can apply to export, right? That you can still investigate exports. I agree there probably would be a constitutional problem with posing tariffs on exports, but that's a distinct part of the statute. Just because that word export might be unconstitutional does not mean that when applied here that the word is that it's unconstitutional. It's the same word, right? The word regulation is not changing. It's just that sometimes you could use it in a way that's unconstitutional. I think foundational, we understand you could also regulate in a way that violates the First Amendment or violates Equal Protection Clause, but just because you could act unconstitutionally in another means doesn't mean that this means in this case is unconstitutional. As to Title 19 and the other tariff statutes, yes, there are other tariff statutes, but a sensible tariff statutory program gives both emergency and non-emergency powers. So it doesn't make sense to require the president to jump through the hoops of the non-emergency powers when the president has declared an emergency and is using special emergency authorities. And then finally, the Chief Justice Marshall point. Yes, the district court makes that point. They say, look at Chief Justice Marshall and Gibbons says that regulating and taxation are distinct. I slightly feel bad for the clerk in that case, because if you just continue reading the opinion, Chief Justice Marshall says, but of course, tariffs can be either taxation or regulation. So it doesn't make sense to me why, I think perhaps the court didn't read the whole opinion in Gibbons. Yes, taxation and regulation are different, but Chief Justice Marshall himself says tariffs, he says duties, can be either. So I don't think that the Gibbons opinion helps the other side, but thanks for the remarks.
Just briefly, I did bring, this is my client, Emily Lay's payment of her tariff of 25% to China. It isn't a regulation, it's a tax, and it can't be argued. You can argue the purpose, but it is a tax. This was not paid by anyone named Z, right? This was paid by my client and not the head of China. So I do think the purpose is going to be, I don't think the purpose of it, whether it's under regulation or under tariff, matters. But I also think, and I'll yield my time to Chad, because one thing you didn't point is every lawyer in this country is going to be looking for the word regulate, particularly in the government. If this goes through, aren't they going to say regulate's been used this way? We can use it in this other statute. What do you say to that if you give them a minute?
So my response is we are not just talking about the word regulate, right? I think a reasonable reader recognizes that Congress in different statutes empowers different people to regulate different things. So this statute uses the term regulate importation. So it's been argued, for example, oh, well, the SEC, they can regulate trading. That's different than trading on markets like the NYSE or whatever. That's different than regulating importation. Or the EPA can regulate greenhouse gas emissions. Well, greenhouse gas emissions are different than importation. So you'd have to find other statutes, I think, that say regulate importation to kind of have that objection.
Okay, great, thank you. I'm going to take the moderator's prerogative and ask a couple of questions to kick off the Q&A component, and then I'm looking forward to opening up to audience questions as well. So here's my first question, and as I did clearly say, right, this is not my area of expertise, but I'm going to try anyway. All right, the Commerce Clause, third clause of Article 1, Section 8 of the Constitution, grants Congress the power to regulate commerce with foreign nations. Professor Squitieri argues that the imposition of tariffs can be properly understood as an exercise of the commerce regulation power under the Commerce Clause, because tariffs are a common means of regulating commerce, and thus that IEPA, by empowering the president to regulate importation, can be properly understood as empowering the president to impose tariffs. So the key to this argument is that middle part, namely that tariffs are a common means of regulating commerce. From an economics perspective, this is plainly correct, right? From that perspective, one can view a tariff as what economists would call a Pigouvian tax, right? A charge designed to increase the cost of a market activity in order to reduce that activity and any negative externalities associated therewith, akin to carbon taxes, congestion taxes, and so-called sin taxes, right? Taxes on tobacco or alcohol or the like. From this perspective, the purpose of the tariff is not to raise revenue, but to regulate behavior. That's exactly how economists think about any sort of tax, including a tariff. So this question really is probably directed to you. What do you make of this argument?
What I make of it is that in an emergency, you don't reach for tariffs, you reach for embargoes. I think that that's undermined by the idea that this is an emergency statute. An emergency means something has arisen immediately, you stop it. Do we only want a certain amount of fentanyl coming from Canada? Do we only want a certain amount of fentanyl coming from Mexico? So the president just knows the right tariff to get just the right amount of fentanyl so we have just the right amount of deaths from fentanyl, right? No, you embargo it, you do that. So the emergency part of the statute doesn't match a tariff idea of the statute, because even economists will say, yes, you might tariff things if you think there's something unfair going on, but that is not what you do in an emergency.
Let me give you a chance to respond.
Sure. A response to you and to John. To quickly to John, I mean, in an emergency, you can use different actions, right? If there's an emergency at your house, you might lock the door or barricade the door or call the police, or if need be, like open out, have your weapon, your gun. In our system, it's up to the president to determine the appropriate way to respond to the emergency. So sometimes that's going to be to slow importation. Sometimes that will be to stop, to barricade the door. The response to the economics point, which is not my specialty at all, I think there's two separate arguments, and I'm only making one. One argument is that you can use a taxation power to regulate. I'm not making that argument. I actually don't have a position on it. The second argument is you can regulate to regulate. Right? And I'm making that argument. You can use the commerce regulation power to regulate imports. It's a whole separate issue about whether you can use the taxation power to regulate imports. Tariffs are unique. They can be both. They can be a exercise of taxation power or exercise of commerce regulation power.
Okay. Second question from me. I believe it's fair to say that President Trump has imposed tariffs with multiple objectives in mind. His stated reasons include boosting American manufacturing, reducing trade deficits, pressuring other countries on policy issues, and raising government revenue. Let me focus on that last reason, raising government revenue. Professor Squitieri, does this complicate your argument? Let me elaborate. Perhaps, maybe you're old enough, perhaps you remember the Seinfeld episode when Jerry Seinfeld tries to return a blazer. When the store clerk asks him why, he says, for spite. She then says he can't return an item for spite, and when Jerry tries to change his answer to a valid reason, now the store manager, who's been called in to adjudicate, says, well, you already said spite, so, and he refuses to accept the return. So like Jerry, President Trump has already said for revenue. Does this imply that his tariffs should be properly understood as an exercise of the taxing power under the first clause of Article 1, Section 8, and not of the commerce regulation power under the Commerce Clause?
So I think I am familiar, I saw it as a clip, I think on like Instagram or something like that. It's a great question. It's a legally significant question, but I think the answer cuts in the president's favor. So commerce regulating tariffs can raise revenue as an incident to regulating commerce. And you just kind of think through it economically. Even if the tariff is regulated at even if the tariff is really high, like $1 million per t-shirt or something like that, it's intending to severely limit how many t-shirts are coming in, or maybe even prohibit t-shirts. You know, a couple t-shirts are still gonna probably come in. Some rich guy is still gonna, pay his $1 million and get his t-shirt. So that will raise revenue. What matters on the founding, and Rob Natelson has like the definitive article on this. At the founding, what mattered was the tariff imposed primarily to raise revenue or primarily to regulate commerce? All the legal evidence here indicates that the tariffs were imposed primarily to regulate commerce. You look at the executive orders, they don't stress revenue. They talk about things like stopping the drug trade from coming in. To go to John's point earlier, the president's not saying, I want some drugs to come in and I'm going to tax them. He's saying, I don't want any drugs coming in, or I want to protect domestic manufacturing, which is a traditional exercise of commerce regulation power. So it's, yes, the administration now goes around on TV and talks about, look, American people, this is raising a lot of revenue, but politicians highlight positive results of their policies all the time. The legal evidence here indicates that the tariffs were imposed primarily to regulate commerce, and commerce regulating tariffs can, as an incident, raise revenue, and that doesn't make them unlawful.
Give you a chance to respond, if you wish.
I don't. I think that I think that he may be right about this because of Trump v. Hawaii, which is you can look at stuff the president says, but I think they're more likely to look at the EOs. So I don't really have a big disagreement. I do think it's a bad look, but it's more atmospheric, like whether these things are emergency. They're not going to talk about it, I don't think.
All right. So my next question, and I think it'll probably be my last before I open it to the audience, is directed at both of you. And so I'm open to either of you taking a first crack. So looking more closely at the text of IEPA, and this has been mentioned before, that it does not just say regulate importation. That phrase is actually, there's an ellipsis in the middle of that and a lot of other things in between, right? So what does it say? It says it gives the president authority to regulate, to the power to investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or a national thereof has any interest by any person or with respect to any property subject to the jurisdiction of the United States. I'm not going to read that again. So when I extract from that the phrase regulate importation, does that phrase include the power to impose tariffs or duties? How should the other terms in that list of powers inform our understanding of what regulate importation means? Now, I know this has been touched upon already a little, but I'm prompting you to focus on this and maybe try to go a little deeper. Perhaps you should start. Yeah.
Sure, yeah. So I would go back to something I mentioned toward, it's a great question, to start toward the start of my talk, where I mentioned, well, IEPA gives the president various authorities. Three important ones are investigate on one end. That's like low level stuff, right? Let's look into it. Prohibit, that's pretty aggressive. And then in the middle is regulate. There's some other words in the middle too. I think that's consistent with my earlier point where, okay, in an emergency, Congress doesn't know what the proper way to respond to an emergency that's going to happen 50 years in the future, what the proper way to do that. So they give the president a lot of different opportunities, powers to choose from. And I'll just add that, particularly the word prohibit, that informs that regulate is a commerce regulating, that the word regulate is delegating commerce regulating tariff authority, because since the founding, commerce regulating tariffs could be used both to kind of regulate or slow down importation and prohibit, right? Think of make it $1 billion tariff on cotton t-shirts, right? Who's going to pay $1 billion for a cotton t-shirt? And that's been the case since the founding. So I think that informs that the term regulate in the middle of like that kind of lots of different words you mentioned does provide tariff authority.
It would have been so easy to have tariff authority. They knew all the words. They're all over the Constitution. They're all over, Title 19, right? But they're nowhere here. The absence of those words is important as well, that none of them are there. So I don't think they're there. But there's another thing that Professor Squitieri said that I forgot that it annoyed me. He said that there's been a judicial determination that regulate means this. That is in this case called Yakuta from the Federal Circuit, which is why the government wanted to get to the Federal Circuit. And it's from like 1973. Nixon imposed these tariffs under a previous statute. and said, well, look at this previous statute with the language that's in IEPA, a lot of it. And they said, well, he can do this. And they went around and they used all the words that you've just said and said, we're going to let him do it. It's in the realm. But if you read that case, you can see those judges taking off their robes and they have like bell bottoms on and they're out there with disco. I mean, it is written in such a non-textualist, originalist way that I don't think it should be cited to the Supreme Court today.
Do you want to comment on that?
Yeah,
case?
I would add, I don't have a strong opinion on like the methodology of the disco era jurist, but
I do, as you heard.
I will say that for a modern day originalist or textualist who's trying to triangulate the original public meaning of a statute or what the public think it is, some important congressional outsiders, to borrow some language from then Professor Barrett, is that court, right? Whatever methodology they were using, they're outside of Congress, they said regulate importation, that means tariff. And then was it 3 years later, Congress reenacts the same statute. In the legislative history, which, right, we're at FedSoc, I'm not supposed to mention legislative history, but in the legislative history, they
Same language, different statute.
Yeah, same language in the new statute, yeah. In the legislative history, they reference that case. So there's some familiarity with the case. So yeah, I think just as kind of like, you should probably give that case, if you're a textualist, like you would look at, okay, here's a New York Times article talking about the statute from that era. They said it meant tariffs. That's not dispositive, like one New York Times editor, but it's like good evidence of what the original public meaning is. Same with this judicial opinion where you say, well, look, they're reading the statutory language. They say it has tariffs. That's good evidence. So that'd be my response.
I actually lied. I think I'm going to take the prerogative to ask one more question.
Is it another economics question?
No, but your back and forth prompted, so maybe it's two parts of a question. So with respect to the Yohid case, I thought one important distinction was the scope of the emergency there, that it was far more narrow and time limited than the ones President Trump is citing to now. So I'm wondering if that matters. And then the related point that you raised about legislative history, if the legislative history indicates that Congress did intend to limit these statutory emergency powers available to the president, right? It was enacted, IEPA was enacted specifically after abuses of the Trading with the Enemy Act, which did not limit the scope or duration of economic emergencies, did not require presidents to invoke specific statutes, did not establish a vehicle for congressional oversight. And when Congress passed IEPA, it placed guardrails in all these areas, and it terminated all existing presidentially declared emergencies as part of its effort to rein in the executive branch and start with a clean slate. So is President Trump's use of IEPA here to impose tariffs, is it consistent with Congress's intent in passing the statute? And it does seem quite distinct from the emergency being relied upon in the Yohida case.
Yeah, so I kind of agree with that, but I'm gonna throw a bone here, and that's this. It's kind of all or nothing to me. So they said that that Nixon's tariffs, because we were going off gold, it was a big deal, and so they said it was limited in time and all this, so we're going to allow it. But I think that just like the Voss decision, where they struck down these tariffs, but I think they left room that there could be other ones. I think either the statute allows it or not. And it's the way I look at these things. It shouldn't really matter if I'm right, and Professor Squitieri is right that they're not going to look at the emergency. They may look at the fit, though. I will say this: we haven't talked about this. The statute does require that what was decided on as the response to the emergency has to fit the emergency. They may do that, and that may matter. That I think that Yakuta and the Voss decision should be looked at as fit arguments, which is valid.
Yeah, I generally agree with that. I think you can point to policy differences between the Nixon tariffs and President Trump tariffs, but I don't see why those, like different tariff rates or whatever, I don't think why different tariff rates, why that would matter as a statutory problem. And indeed, in like often in non-delegation cases that probably John has litigated a bunch of them, the executive branch will often be like, well, look, we've like curtailed our own powers. We're only going to like do this little bit, not all of it. And the Supreme Court has said, no, what matters is what the statute says, not like you holding your own hand. As far as the legislative history, so I guess I'll just, I lost a class of students. As a textualist, I don't particularly care about legislative history except for the effect it can have in triangulating original public meetings. So again, treat it essentially as like a New York Times opinion or some commentary. It's not dispositive, but it kind of informs what congressional outsiders, what the public thought about things. So I don't like kind of like going down the rabbit hole of saying, well, they're trying to limit this statute and therefore this means that or what have you. I think that gets into problems that textualists reject. And I'll add, I think it's the Solicitor General's brief, most recent one, talks about how the IEPA, when the Congress is trying to limit authority from like the TWEA to IEPA, they limited the authority in ways that are like not relevant to here. So yes, that statute may have been trying to limit executive power, but not in this sense. It was in one of the briefs, I believe it's the SG's brief.
All right, thank you. I will now yield the floor to the audience. So just raise your hand and microphone will appear.
Hey, thank you all for your time tonight. Imagining the court decides the president doesn't have this authority, what's the remedy for importers who have paid their tariffs and those tariffs have already been liquidated, so they've already gone to the Treasury?
So I'll answer this unless you want to. So the CIT, the Court of International Trade, is actually just set up. What it mainly does is when the way tariffs work is they say, okay, there's this tariff on these kind of widgets. And then you pay the tariff, but then you can protest that I have a different kind of widget that has a lower type of tariff on it. So they have a whole refund setup. I think people can just go to the CIT, and I think they have to give the money back regardless of what the Treasury is. I mean, I think it'd just be ordered. But this may be so massive that it'll require this is just my speculation because I don't know because I'm not a trade lawyer. It may require congressional action, or it could require the CIT to set up special procedures because it's just so massive, like, I don't know, an MDL or something. I mean, I don't know, but there are laws that allow you to go to the CIT if you've paid money you shouldn't have paid.
Yeah, I would add, I'm sure there's plenty of case law. I agree with that. There's probably plenty of case law on this, but I could imagine some sort of like appropriations clause problem if there's not a statute allowing the court to order all of that money to go to the entities. There probably is a statute, so there probably won't be an appropriations clause challenge, but I could imagine litigation about it. Yeah.
I've joked that next year the administration will be touting that it's responsible for the largest tax refund in American history.
Tariff refund.
Yeah, hi, excellent debate. And just following up on that, in terms of if the court does strike it down, besides going to the CIT, I guess the Court of Claims here might also be pretty busy trying to get the refunds or claims. But Congress, of course, could just pass a law ratifying all these tariffs. Isn't that true? I mean, they have the power. That's what you're arguing, that it's their Congress's power, not the executive's.
I don't know. Here's what I don't know. If they were illegal tariffs ab initio, then isn't it a taking? Then you go to the Court of Claims, right?
Good point.
Right?
Yeah.
So then they'll go to the Court of Claims and not the CIT. And what I mean by this is, for each of these courts has a special jurisdiction, and the Court of Claims, if you sue the United States for injuries you suffered to your property or person, you have to go to the Court of Claims. If you have a tariff problem, you've got to go to the Court of International Trade. I think you should go to the Court of International Trade, but what's just been proposed here if Congress did that, I think you'd go to the Court of Claims and have a big fight over taking, wouldn't you?
But that presupposes Congress will ratify it, but.
Congress isn't ratifying these, you
Well,
know.
not, but authorizing them.
Yeah.
Obviously, the Senate would vote for 60. But a related question, the argument's going to be next Thursday in the Supreme Court.
November 5th.
November 5th. What should you be looking for in terms of who's going to be saying what on the bench?
You want to take it first? Because I got strong views.
I'll let you express those strong views.
All right. Limiting factors. Professor Squitieri is very good at saying what the limits are on this. I think they're all parchment chains. They're not real limits. And what happened below in the federal circuit is Brent Schumate is a very good lawyer, but I don't think he was given the ability to limit what's being claimed here for power. And I don't think John Sauer is going to be given that limit either. And so most of the court's going to be who might be open to the administration's argument is going to be looking for what's the limit, because what's the next case. And I don't know that they'll give the Solicitor General running room. And so I think you want to look at Barrett. You want to look at Barrett because she's going to know about this jurisdiction question, I think. There's a question whether it's in the district courts, the CIT. And then I think you want to look at Roberts and Kagan, because here's how I think this is going to play out. Kagan is going to get all the textualists and the originalists, and she's going to beat them about the head and body with everything they've written before about specificity and all these other things. And John Roberts is not going to want any dissents on this, because this is a major thing from the administration. He wants to either write this himself or give it to Alito so that when it's 9-0 on whatever they decide, no one can say that it's some kind of maniac from the left wing who did this, off in a corner somewhere. So I think those are the main. You look at Kagan, you look at Roberts, you look at Barrett.
I think the originalists would agree with me because I do think the originalist evidence is pretty overwhelming. I understand it's a very high-profile case. One thing I'll assign some homework to the law students is go back and read the non-delegation case from last term. I think it shows some hands. It was written, I think, very carefully, knowing that this is going to be a big case this term. And I think there's a lot of stuff in that opinion that suggests that leans in the president's favor on tariffs. But I'm not a good predictor about these things.
No, I'd go listen to that anyway. You're right. Certainly the argument in that case, but there'll be some similar things.
Thank you all. Mr. Vecchione, you touched on the limitation of fit, that even if the IEPA does authorize the president to impose tariffs under the statute, they have to deal with the crisis. So I would love, Professor Squitieri, if you could respond directly to that. Do these tariffs deal with the fentanyl crisis? And is this a question for the judiciary, or is it non-justiciable?
Yeah. My opinion on this is that deal with it's a statutory limit on the president. I think this kind of highlights what you're talking about limitations and some sensitivities about arguing that. But it is a statutory limitation on the president's authority. Now, should courts often second guess the president's inherently political decision about policy decision about what deals with a threat? No, but on edge cases, it is a statutory limitation that I think courts can enforce in edge cases. So I think that is very relevant to the non-delegation inquiry. Still leaves a lot of discretion. But again, if you look back at like that pizza example from the non-delegation case, where the only limitation, or the only relevant limitation was, dear executive branch, you can raise as much taxes as you want so long as it's sufficient to support a government program. By the way, the agency could define the government program. So obviously, if you define it bigger, you can raise more money. If you define it smaller, you can raise less money. And Kagan says, right, if you tell someone gets pizza sufficient for 5 people and 500 boxes show up, they haven't followed the instruction. Her point there was saying, look, the statute constrains, therefore no problem under non-delegation. Apply that same analysis here. If you tell someone to get pizza to deal with 5 people and 500 boxes show up, I think the same analysis applies. So it constrains as statutory matter, and that's good enough for non-delegation. Particularly remember, that case from last term was domestic taxation, where the non-delegation doctrine applies more stringently. This is foreign affairs context, where the non-delegation applies far less stringently, if at all. That was a long answer, sorry.
I'll just add, I will take Professor Squitieri's hypothetical. If someone's trying to break into your house and you don't lock the door or get a gun and you just charge him for entry, I don't think that is really solving the problem. So I think it's going to be the same sort of thing, and the fit won't be any good.
So, Professor Squitieri, you keep going back to the recent non-delegation cases, but you yourself have said that you don't think that even J.W. Hampton was correctly decided on originalist grounds, which dealt with a flexible tariff ratio. So, let's say we go full Clarence Thomas and throw precedent to the wayside. Why should the court care about precedent when the originalist approach to non-delegation says this is a clear violation?
So a couple of responses. One, I get that you're kind of being humorous about the Justice Thomas point, but that's not his view about precedent, right? He is more respectful of precedent than that question would suggest. But to the originalist argument that oh yeah, another thing too, sorry. The other day I kept talking to my wife, we were planning like a trip, and I kept mentioning a hotel. I kept saying like, we're going to the J.W. Hampton. She's like, what is that? And it was the J.W. Marriott. So sorry. Okay, now I'll finally answer your question. I've argued, as I think you're referencing, that as an originalist matter, the non-delegation principle should apply differently to different powers. Because if you look, right, Article 2 vests the executive power, all of it, in the president. Article 3 vests the judicial power, all of it, in the Supreme Court and whatever inferior courts Congress wishes to create. And then Article 1 uses different words. It does not vest the legislative power. It vests all legislative powers herein granted, and then specifically enumerates different powers using different words. And that's because the founders were afraid of an overly powerful Congress. So those original meanings of those different words, I think, permit Congress to delegate those different powers differently. And in the foreign affairs context, I think Congress can delegate more easily to the president. Yeah, so that's my answer. Thanks for reading my stuff.
I am not going to wade into J.W. Marriott.
I actually think we've reached time, so I'm just going to close by thanking our debaters and inviting you to join me here. Thank you.
Thank you all for coming. Our next debate will be Wednesday, October 15th, and it will be on whether Trump v. United States was correctly decided. Thank you again.
I'm just amazed that you pulled this off. How many times? You too. It's great.